Can you sue a state or the United States government for denying a firearms transfer due to erroneous information? In this video, I will discuss the firearms transfer process, the reasons for delayed, denied, or open responses, as well as your right to sue the responsible state, political subdivision, or the United States for an order directing that the erroneous information be corrected or that the transfer be approved, as the case may be. This is Christian attorney R.L. Johnson, lawforlife.us. If you're new to this channel, I explore legal issues from a Christian perspective. So if the Christian perspective interests you, please be sure to subscribe to this channel. Individual self-defense is a central component of the Second Amendment right to bear arms. Those are the words of Justice Clarence Thomas in the June 23, 2020 case of New York State Rifle and Pistol Association versus the Superintendent of the New York State Police. Last June, the United States Supreme Court told us that New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. This might lead some people to believe that the government can't restrict a law-abiding citizen's right to bear arms for self-defense. However, since September, roughly 10% of all firearm sales have been delayed by the Brady Handgun Violence Prevention Act of 1993. To put that in perspective, as of September of this year, over 1 million total firearms were sold. 10% of those sales, which is roughly over 100,000, received delayed responses due to the Brady Act. Now, at this point, I think it's necessary to state that all law-abiding citizens and responsible gun owners appreciate the need to keep weapons out of the hands of dangerous criminals and maniacs. But the question is, what can a law-abiding citizen do when, due to erroneous information and bureaucratic snafus, they're not able to exercise their Second Amendment right? What can a citizen do when a delayed potential transfer remains in open status, which could put a perpetual hold on the purchase of a firearm? This is a question that I intend to address in this video. But before getting into how to go about dealing with a delay or a perpetually open hold on the transfer of a firearm, I think it's instructive to talk a little bit about the Gun Control Act of 1968. The Gun Control Act of 1968 prohibits certain categories of persons from shipping, transporting, processing, or receiving firearms or ammunition in or affecting interstate commerce. This prohibition applies to 10 categories of individuals. The first is persons who've been convicted of a crime in any court punishable by imprisonment for a term exceeding 1 year. The second is fugitives from justice. The third is unlawful users or persons addicted to a controlled substance. Fourth are persons adjudicated to be mentally defective or committed to a mental institution. Fifth are illegal aliens unlawfully in the United States. Sixth are persons dishonorably discharged from the armed services. Seventh are U.S. citizens who have renounced their U.S. citizenship. Eight are persons subject to a court order that restrains them from harassing, stalking, or threatening or intimidating a partner or a child of such intimate partner. 9 are persons convicted in any court of a misdemeanor crime of domestic violence. And 10th are persons under indictment for a crime punishable by imprisonment for a term exceeding 1 year. So under the Gun Control Act, if any of those things is actually true about a person, he or she may not lawfully purchase a firearm. Now, I want to talk a little bit about the firearms transfer approval/denial process. Now, in order to prevent one or more of the prohibited individuals discussed above from obtaining a firearm, the Brady Handgun Violence Prevention Act of 1993 directed the Attorney General to establish a background check procedure that licensed firearm dealers, sometimes known as FFLs, will be required to consult in order to determine whether a transfer of a firearm to a potential buyer would likely violate federal or state law. Consequently, the Attorney General established the National Instant Criminal Background Check System, sometimes referred to as NICS, which is managed by the FBI's Criminal Justice Information Services Division. Since the enactment of the Gun Control Act, I believe that every state in the Republic is now required to contact the NICS by telephone or via the internet in order to initiate a background check prior to the transfer of any firearm. In its request, the firearms dealer must provide the NICS with identifying information about the purchaser, which includes your name, sex, race, date of birth, and state of residence. Also, although not required, it's usually helpful to provide your social security number to avoid being confused with someone with a similar name. Now, once the firearms dealer transmits your information, the NICS section assigns the transaction a NICS transaction number, or NTN. The NICS provides that number to the firearms dealer, and then it searches 3 electronic databases: the Interstate Identification Index, the National Crime Information Center, and the NICS Index. All All of this is done to determine whether there's a state or federal record establishing that, for any reason, you are prohibited from receiving a firearm. If the search yields no disqualifying information, the NICS section provides a proceed response to the dealer. However, if at least one record is found that establishes that receipt of a firearm by you would violate state or federal law, the NICS section provides a denied response to the dealer. Another possible outcome is that the NICS section locates a record that requires more research to determine whether or not you are disqualified from possessing a firearm by federal or state law. In that situation, it provides a delayed response to the dealer. In the delayed response scenario, the transaction remains open and the dealer may not complete the transfer unless one or two things happens. The NICS section later provides a follow-up proceed response, or 3 business days exclusive of the day on which the request was made elapse, and the NICS section does not provide a denied response. This is sometimes referred to as the Charleston loophole, which is seen by many as a dangerous gap in the federal gun control system because it allows gun sales to proceed after 3 days even if the background check has not yet been completed. As a matter of fact, contrary to federal law, some people believe that states can on their own initiative address this loophole by giving a background check operator more time to determine if a buyer is prohibited from purchasing a firearm. But I digress. Now, getting back to an open transaction. An open transaction is considered a non-canceled transaction where the federal firearms dealer has not been notified of a determination. During this open status period, the NICS section is continuing the search for potentially prohibiting records regarding your request for a transfer. The good news is that if the NICS has not contacted the federal firearms dealer with a denial after 3 business days, the federal firearms dealer is not prohibited from transferring the firearm to you. So again, the question, what should you do if you receive a flat-out denial, or if your transfer remains in open status so long that it effectively places a perpetual hold on your purchase of a firearm? Well, really you have 3 options. The first is to seek a correction of the erroneous information, either through the point of contact at the state or political subdivision where the erroneous information originated. You could also voluntarily appeal the erroneous information with the FBI. Finally, you may contest the accuracy or validity of the disqualifying record by bringing an action against the state or political subdivision responsible for providing the contested information, or you can sue the United States government. Now let's take each of these one at a time. As I explained earlier, federal law and federal regulations govern the correction of or challenge to erroneous records resulting in the denial of a firearms transfer. Note well that while the FBI does maintain an automated national instant criminal background check system, that's the NICS, which has an audit log of all incoming and outgoing transactions, the denial you receive will not state the reason for the denial. Moreover, the NTN and the date of all transactions, whether it's an FLL given proceed, an FLL given denied, or an FFL given delayed response, the federal government retains these responses indefinitely. Conversely, records related to open transactions, except for the NTN date, are destroyed after 90 days. So if the NICS section issues a denied response, you can request an explanation. The federal firearms dealer must provide you, the denied individual, with the name and address of the FBI and the NTN associated with the background check. Your request for an explanation must be made in writing to the denying agency. The denying agency will respond to you with the reason for your denial within 5 business days of the receipt of your request. So the first option, if you wish to challenge the accuracy of a record upon which the denial is based, or if you wish to assert that your right to possess a firearm has been restored, you may first apply to the denying agency. If the denying agency is unable to resolve your appeal, the denying agency will notify you and must provide the name and address of the agency that originated the document containing the erroneous information upon which the denial was based. Then, you may apply for a correction of the record directly to the agency from which the record originated. If the record is corrected as a result of your appeal to the originating agency, you may notify the denying agency, which, assuming the originating agency has not already notified the denying agency of the correction, will, in turn, verify the record correction with the originating agency and take all necessary steps to correct the record with the NICS. Now, the procedure I just outlined applies where the state point of contact was the denying agency. However, you may also elect to direct your challenge directly to the FBI. Again, these challenges have to be in writing, and for this type of challenge, you have to mail your request to the FBI's NICS Operations Center in Clarksburg, West Virginia. I placed the address in the description box. Now, upon receipt of your challenge to the FBI will investigate the matter by contacting the POC, that is the state entity that originated the erroneous information, Then the FBI will request that the POC verify that the record in question pertains to your denial, or verify or correct the challenged record. Now, in this challenge process, the FBI will consider both the information it receives from you and the response it receives from the political subdivision or state that maintains the data source. Now, if the record is corrected as a result of your challenge, the FBI must notify you. The FBI also has to correct the erroneous information in the NICS database and give notice of the error to any federal department or agency or to any state that the source of the information was erroneous. After the FBI notifies the originating entity whose false information caused the denial of the firearms transfer, that denying entity must provide a written confirmation of the correction of the erroneous data so that you can go back to the gun store and present that written information to the federal firearms dealer. So the obvious question is, how long does all of this back and forth take? Well, if 30 days or less have transpired since your initial check and there were no other disqualifying records upon which your denial was based, the NICS is then required to communicate a proceed response to the federally licensed firearms dealer. On the other hand, if the appeal is successful and more than 30 days have transpired since your initial check, the federally licensed firearms dealer must recheck with the NICS before allowing you to purchase your firearm. Additionally, in cases where there were multiple disqualifying records, you have to pursue a correction for each record. Next is the voluntary appeal file. In addition to the record correction process, you can provide the FBI with written consent to maintain information about you in what's known as a voluntary appeal file. A voluntary appeal file is established by the FBI and checked by the NICS for purposes of preventing future erroneous denial or an extended delay by the NICS for a firearms transfer. Last but not least, we get to suing the responsible state, political subdivision, or the United States itself. Under federal law, you may also contest the accuracy or validity of a disqualifying record by bringing an action against the state or political subdivision responsible for providing the contested information, or responsible for denying the transfer, or you can bring it against the United States as the case may be. Here, you're seeking an order directing that the contested information be corrected or that the firearm transfer be approved. But be careful here, because there is some caution that you need to take before suing the United States government. Namely, while the regulations governing appeals of denials based on erroneous information provide that you can actually ask for a correction to be made, that is to go through the correction process I mentioned above, you can also ask for a voluntary appeal file to be opened, and under the regulations you can actually file suit against the state, political subdivision, or the United States all at the same time. But you have to be careful in the cases of delayed and or open responses. That is to say, you may run into a judge who rules that you may not obtain judicial relief if you have not first exhausted your administrative remedies. And the administrative remedies would be for you to essentially go through the correction process or the direct appeal process to the state or political subdivision or to the FBI in an attempt to either get a flat-out denial together with a reason for that denial. Now, the doctrine of administrative exhaustion basically was something that was put into place a long time ago, essentially, to make sure that you're not just clogging up the courts when there are other remedies that are less drastic available to you. So if a government entity has carved out a process for you to seek relief based on a grievance that you have about some administrative action, then the courts expect you to take full advantage of that until the point when you can go no further with that entity. Now, this is not just some obscure loophole or provision in law. The triggering event in the enabling statute that allows a citizen to sue the government or the state or a political subdivision requires that the responsible entity have denied or been responsible for the denial of the transfer. So the denial is a triggering event. So if you haven't received a denied response, your lawsuit, frankly, is not ripe to present to a court. So this is why I say that you have to either have a flat-out denial or your transfer has to have remained open so long that it effectively places a perpetual hold on your purchase of a firearm. Indeed, if you encounter a Brady hold, that's the 3-day hold, or later receive your firearm after 3 days, you probably don't want to sue the federal government to either correct erroneous information or ask that the transfer be ordered, because on the one hand, you've already received a weapon, and on the other hand, the federal government has no duty to correct records that originated at a state or local level. If you find this content useful, please be sure to like this video and to subscribe and share this channel. Also, if you're looking for more information or resources on this subject, I posted an article on my blog, lawforlife.us, where you'll also find other helpful information, content, and resources. Thank you for watching. God bless.